Say your full name. Paul Holloway.
Thank you, sir. Holloway, we've got some traffic matters we're going to deal with first before we get to your 3 other cases. Apparently you missed some court dates on these traffic matters, and when you miss those dates, a judge issued an arrest warrant for you. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and if you cannot afford an attorney, the court will provide one for you. Do you understand those rights, sir?
Yes, sir.
All right. First ticket is P1143669 with charges of driving unregistered vehicle, no insurance misdemeanor, and driver's license expired. P1159390, driving unregistered vehicle, driving while license suspended, no insurance misdemeanor. P1159407, open alcohol in a motor vehicle as the driver. P1159412, failure to report an accident, leaving the scene of an accident causing property damage. P1170052, open alcohol in a motor vehicle as the driver, driving while license expired, no insurance misdemeanor. P1170301, driving unregistered vehicle. P1170304, improper plates. And Z8086391, operating while intoxicated, first offense. Sir, these are all misdemeanor charges. Maximum penalty you face on each is up to 93 days in jail and or $500 fine. I'm going to set aside the arrest warrants, enter a not guilty plea on your behalf, and give you a personal bond. Your next court date for these matters is a pretrial April 2nd in front of Judge Millhouse here in 36th District Court. Now for your other matters. Which all appear to be misdemeanors in front of Judge Bryant. So we'll call them all together. We've got case number 1904647, State of Michigan versus Paul Martin Holloway. Case 2004448, State of Michigan versus Paul Martin Holloway. And 2304539, State of Michigan versus Paul Holloway. Counsels.
Jennifer Douglas for the people, P72748.
And yes, Your Honor, Brandon Bird on behalf of Paul Holloway. My client waives his right to the formal reading, was advised his constitutional rights, and will stand mute.
Will enter not guilty plea on your behalf. The capiases are as follows. The 19 case has a $1,000 10% capias. The 20 case has a $1,000 10% capias. And the 23 case has a $1,000 10% capias. Esteban.
Your Honor, the people are asking for the capias bond amounts to stay in place. We're also asking for a tether to be added on each of the cases, so that whatever happens in one particular case, there is still a tether for him. Your Honor, as the court can see, Mr. Holloway has multiple capiases and multiple cases. The case ending in 5309, he has one failure to appear, but in the case ending in 6497, that's listed as number 11 on the docket, he has 5 different failures to appear. And with that, actually, some of those, it looked like he did actually post bond a couple times and still failed to appear. The case ending in 4489, he failed to appear a number of times. Your Honor, he has a pending case at Third Circuit. It's a breaking and entering a vehicle case. that it's case number 23-000500-01FH, and he actually had a failure to appear on that on looks like August 3rd of 2023 at a final conference, and he was not arraigned on that until September 29th of 2023. So, Your Honor, almost 2 full months later. He was given a tether in that case, and at some point he had a tether violation. So, Your Honor, we have a series of failures to appear, of picking up new cases, Your Honor. And so, given the large number of failures to appear, we believe that, and considering that he did actually post the nominal bonds a couple of times in case 6497, we believe that in order to ensure that Mr. Holloway appears for court, is in fact a tether, and that is why we're asking for those bonds to remain the same, to be continued, and for there to be a tether condition added to his bond.
Thank you.
Yes, Your Honor. My client indicates to is 56 years old, lifelong resident, Your Honor. All his prior criminal history is all nonviolent, Your Honor. Indicates to us that there's no amount of bond he could afford to pay. And according to my client, he was in the Wayne County Jail on November 14th and 15th. Yeah. Respectfully, because of that, we're going to ask this court for a personal bond. He understands that he has to show up to court. And we're going to ask this court for a personal bond, Your Honor.
Okay. Ms. Douglas, do you have any information on the defendant being in Wayne County Jail?
Your Honor, I don't have any information on him being in jail. As far as November 14th or 15th goes, I know that he had some court at Third Circuit on November 2nd, and then on November 17th that he appears to have shown up for. I don't have anything to indicate that he was in jail at that time, but I can't say that he was not.
Mr. Bird, is your client employed?
No, Your Honor. Unfortunately, he's unemployed.
Okay. Okay, so the defendant does have apparently quite the history of not showing up, both in these cases and in the traffic matters the court previously did. However, they are non-assaultive matters. Sir, you need to show up and get these cases taken care of, right? Because you're spending days in the Detroit Detention Center just because you didn't show up to court. And that doesn't seem to be, I wouldn't think that to be a course of action that I want to take. Would you agree with me, sir?
Yes, sir.
All right, so court's going to set bond in each of these cases at $1,000 personal with a GPS tether house arrest. One moment for your next court date.
So proud of him. Hey, Your Honor.
Counsel, I think your client wants to say something.
I do.
Yes, and Mr. Holloway.
Hey, Your Honor, every time I keep going to jail, man, I've been in their custody for 4 months. They will not take me to court on these tickets. As soon as I get out, they arrest me and these tickets pop right up, Your Honor. I have not skipped. I've been there. I've been in the county jail 4 months.
All right, Mr. Holloway, thank you. And and if that is the case, Your Honor, I do
it's
feel
frustrating, man, because I keep coming before the judge and I get told to shut up instead of saying, hey, here go my attorney. We can go look right now. See, this guy was in the courtroom for 4 months. He came, he got a bond. Never took him nowhere on these cases while he was in the county. I say something to the lawyer.
Mr. Holloway, I hear you. I understand your frustration, sir. That's why I'm giving you a personal bond.
Okay, thank you.
And Your Honor, just for the record, the register of actions for his Third Circuit case shows that he had a tether violation hearing in January of this year. So he was out at least in January with the tether, and he still didn't come to court here to resolve this. So we would just put that on the record.
Well, I understand the defendant's frustration, and for these matters I have in front of me, we're talking about retail fraud and a B&E, and nonviolent. I want to give them personal bonds on all of them. There will be a GPS tether, however, And sir, your next court date for these three matters is April 25 for a pretrial in front of Judge Bryant here in 36th District Court. Thank you, sir. You're all set.
Black man is Wednesday.
Black line right there. Face the camera. Say your full name, girl. My name is Cordero DeAndre Jones.
Thank you, sir. And this will be case 22045762, State of Michigan versus Cordero Jones. Counsel.
Lisa Coyle appearing on behalf of the people.
Good afternoon, Your Honor. Kashava Kirkland on behalf of Mr. Jones, who has been advised of his rights, wishes to stand mute and waive a formal reading.
Court will enter not guilty plea on your client's behalf. Ask the bond.
Your Honor, there is a capias in this matter from February 27th of this year, set at 1,010% by Judge Bryant. There have been two prior capiases, March 8th, 22, which was set at 110% by Judge Bryant. Again, on December 4th, 23, set by Judge Baltimore at 1,010%. The original bond in this matter was $18,000 personal. I'm recommending that the bond remain in place. This case is about almost a year and a half old. I do not know of any incidents between the defendant and the complainant since 2022, but the allegations are the defendant was drunk and he pulled her hair and he took a gun, which although he's not charged with felonious assault or a brandishing, the allegations are that he racked the gun, keeping it by his side and stating he would shoot the complainant. There were multiple witnesses, and allegedly the video was recorded by the witness. So I'm asking for about that 1,010% to remain in place, and of course, still the no contact with the complainant.
Thank you.
Judge, defense is requesting that you consider turning that $1,000 bond, 1,010% bond, into a personal bond in this case. I understand the court's concern when it comes to his previous capias. Let me know that the December capias, he was actually in the Oakland County Jail, so he was unable to appear at that date. However, when he was released, he was able to be arraigned on that and given a court date, but unfortunately, he got that date mixed up. He is a lifelong resident. He has a child. This is a 2022 case that he, at some point was appearing on for a consistent period of time. And when he did fail to appear, he got a court. He was arraigned on that capias and was able to get a court date. He is working as a security guard. At this point, there's no amount of bond that he can afford to pay. So if he's not given a personal, he'd sit in there on that $100 bond. So we are asking for a personal.
So the bond the capias is currently 1,010%. It was initially arranged back in December of 22. He was given $18,000 personal bond. In March of 23, he failed to appear. There's a $100 10% bond capias at that point. And I gave him a $1,000 personal bond June of 23. He then failed to, no, he appeared late in August of 23. There's a tether that was removed at some point. And in August of 23, there's a very long entry which begins with or ends with the custodial agency, Wayne County Jail, shall hold the defendant named above in its care and custody until bond is posted and the terms and conditions specified in item 5 are acknowledged. Item 5 being a fairly standard list of bond conditions. And the case was then scheduled for October of 23, where the defendant failed to appear. Case was set at 1,010%. That was in December of 23. It was then arraigned later in December of 23.
Your Honor.
Given a personal bond. And then he failed to appear in February of 24. And we got $1,000 10% KPS. And defense counsel, you're suggesting I should give him another personal bond so he can not show up again? What's the thinking there?
Judge, that's the request I'm making. At this time, there's no amount of bond that Mr. Jones can afford to pay. We have talked about, the importance of him appearing in court and how it makes arraignment extremely difficult when he doesn't appear in court. We've impressed upon him the importance of him appearing. We just ask for the court's mercy at this point in time.
Your Honor, I'm sorry. I forgot part of my argument on a note here. I had added it. He does have a pending jury trial for retail fraud first. It's scheduled for May 6th of this year before the Honorable Nicholas Hathaway. In that matter, he has a $10,000 personal bond. The date of offense was back in February 28th of 23. So that case is old as well. But what's I also want to bring to the court's attention, this is an assaultive matter. He had a 2002, 2 counts of A and B under a juvenile adjudication, 2004 assault and battery, 2005 assault and battery, 2006 assault and battery, 2007 armed robbery, and a 2007 R&O. I'm sorry, I did not see my own note attached to my notes. I think that adds a lot to this. Your Honor, if you are going to grant him a personal bond, I would at least attach a tether at this point. He's got a lot going on. He has a lot going on. He still has a pending case set for a felony. So the capias is troubling since he's had, I think, 3 or 4 capiases on this matter. He's got a pending matter and he's got an assaultive background. So I would ask for, at least if you're going to set a high personal bond, set a tether, house arrest, or if he is working, curfew imposed, but to get this matter taken care of.
And Ms. Been a long day. Is your client working, counsel?
Yes, Your Honor, he's working as a security guard. Would you like me to ask him his hours and days?
Yes.
Okay, Mr. Jones, what days and hours do you work?
I work every single day. Why would you put me on the tether when I don't even be around this woman? Come on, it's the reason why I'm this court.
Mr. Jones,
I work every single day. I don't be around.
You're not helping. Mr. Jones, you're not helping. So
05,
I'm going to
06, 07 don't have nothing to do with what's going on right now. I go to work every single day. I go to work every single day.
Does he have regular hours, counsel?
Yes, I work 6 hours a day.
Hours, sir.
Yeah. They put me on.
What are your work hours?
I work from 6 o'clock all the way to 8 o'clock. If you're gonna put me on the tether, just keep me in the county. I don't want to go on no tether. Keep me in the county. I'm good. I've been on the tether twice and I did good twice. I don't need to be on no tether no more. I don't go around Jasmine Gordon. She don't even live in Michigan anymore.
Okay, Mr. Jones, I would advise that you stop making statements on the record. This is all recorded.
I'm just telling you straight. I shouldn't be on tether. She don't live in Michigan anymore.
And I'm letting you know that's not helping. This is not helping.
The prosecutor know that. She haven't heard from that woman. It's just an old case that I should have went to court for, that I should have been got off me. But I haven't because I've been working and I got in and went to the county. I should have been had this case off me.
I would agree with that. All right, so here's what we'll do. While the case is pending, sir, you are not to possess a firearm or any other dangerous weapon. You're to have no contact with Ms. Gore. You will be on a GPS tether. It will be unrestricted as the time and place, so you can carry on your life. But if you don't show up, we'll know where to find you. Bond will be set at $1,000, 10% as indicated in Judge Bryant's capias. Counsel, is that a unaffordable bond?
Yes, Your Honor.
There'll be a bond redetermination hearing Wednesday, March the 6th.
So I gotta pay $100 to get out?
Man, fuck that shit.
In front of Chief Judge McConico. There'll be a pretrial hearing April 29th in front of Judge Bryant here in 36th District Court. All right. Thanks, everyone.
Thank you, Your Honor.